unlike the council's HRA, in the shadow HRA, it's paragraph 4.3.1, the conclusion is reached is that effectively that all of the sites, so not just the QEB site but the other sites, should be screened in, and so the appropriate assessment that's carried out in relation to those sites is carried out in relation to all of the sites and the total increase in visitor numbers. And so there is an analysis there before you, pursuant to which, if you're persuaded by it, and obviously you have to be persuaded by it, you would be entitled to conclude now that the plan is lawful. But it does positively require the retention of the policy OSS 19. So that brings me on to question 111. There are three questions here. The first is what mitigation measures for those sites were initially considered. Well, you can see that from the policy. I'm not going to go over that. The second question is, why are these mitigation measures relating to those sites no longer considered acceptable? And you've heard something about the council's position on that. And that, can I just then cross-reference back, that ties in with what I want to say on question 110B, which is the question whether all mitigation measures have been considered. And the point we make is that on analysis, and I'll explain to you why that is, mitigation measures have not been properly addressed, or in many cases, in large part, not been addressed at all by the council in relation to, well, in relation to any of the sites actually, but I'm focused now more on QEB. Now, in terms of then question 111B, why the measures no longer considered acceptable, I suppose there are two aspects to that question. One is, what was the decision-making process? Well, you've heard about that from the council. That's a kind of chronology narrative issue. We've set out a narrative of that in our hearing statement. I don't go over that. But you'll have picked up that the critical first stage of it was a Natural England letter of the 4th of June 2018, which prompted the reassessment effectively. And the next stage of that reassessment, which you've again heard about from the council this afternoon, is the footprint visitor survey, which Mr. Lilly, I hope I'm pronouncing that correctly, Mr. Lilly has spoken to briefly. And the question here is, the real question here is there any justification and/or a sufficient justification for the change of view? And our point on that is that if you actually look at what those reports say and what the council has made of them, there's been a fundamental failure of analysis. And you get that effectively by taking the footprint survey on the one hand and then seeing what the council made of it in its 2019 or updated HRA. So in terms of the footprint visitor survey, we summarise in our hearing statement, I think this is consistent with what Mr. Lilly says, summarise it under three heads. First of all, it concludes that there are possible impacts of increased recreational use of the common by reason of development allocated in the plan. Well, bear in mind, I mean, there may be a difference of degree about that conclusion, but in relation to QEB, that's not a new conclusion because they'd already screened in possible effects. Secondly, therefore, that without mitigation, it's not possible to rule out adverse impacts on the common. That's paragraph 10.5, and I do emphasise that paragraph 10.5 is directed to all of the development allocated in the plan, or all of the bits we're interested in, ST8, ST9, etc., and not just QEB. 10.5 of the footprint survey. And then C, and I'm put the point in this way, there are mitigation measures which might address this. Now, you heard from Mr. Fleming a moment ago, and it's clear from C, for example, and it's very similar to what you actually see in the 2019 HRA, paragraph 4.36. You heard him say that the footprint survey provides strong evidence, or strong evidence is the wording used in the HRA, that mitigation measures will not address the problem. That's the foundation for the conclusion in the HRA that you can't deal with the problem. But if you go back and look at what the footprint survey itself says, it's quite interesting to note actually that it describes itself as a visitor survey. It doesn't describe itself as a mitigation measures report. But it doesn't describe itself as a mitigation measures report. Well, the question of mitigation is discussed in the footprint survey, and that's at paragraphs 10.6 to 10.20. And what you find, and I'll invite you to look at it, I'm not going to obviously read it all out, but what you'll find in those paragraphs is what I would suggest to you is a generally positive discussion of mitigation. That's not to say, and certainly not to say there's a conclusion there that mitigation, that the adverse impacts identified at 10.5 can be addressed, but it is a discussion which discusses many of the mitigations in positive terms. And the only conclusion which you find in that report is at paragraph 10.20, and I'll just read out the first sentence of that paragraph, but there's nothing in the rest of the paragraph to gainsay this. At plan level HRA, it will be necessary to have confidence that the above mitigation measures are feasible and achievable in order to rule out adverse effects on integrity. So that is definitely not a conclusion that the mitigation will not be effective, or that at the plan level HRA stage it wouldn't be possible to conclude that they're effective. It's just a conclusion that further analysis may be required of those mitigation measures. And I understand there to be a suggestion that if you go to the summary in the footprint survey, you get a slightly different slant. That's on page Roman 4 at the start of the report. And the only reference to mitigation is in the very final sentence, where it says, having repeated the conclusion which harks directly back to 10.5, you can't rule out adverse impacts by reason of the increase, it just says mitigation measures are discussed. So whichever bit of it you look at, you do not find a conclusion in the footprint report that mitigation measures will not be effective. It does not constitute evidence to that effect. It just doesn't say it. And I noticed, I hope this is fair, that when Mr. Lilly was asked to explain why he concluded that the mitigation measures wouldn't be effective, he didn't say that they wouldn't be, even just now. And in any event, if you look at the report, it doesn't say it. So what you have is a footprint report which effectively says we need to look at mitigation, with which we would agree, converted in the 2019 HRA, I think I've given you the reference, paragraph 4.36, to a conclusion that mitigation measures will not be effective. And that's just a failure of analysis. So the answer to the question, have mitigation measures been looked at, even in terms of the mitigation measures which footprint identify, the answer to the question is no. And that's wholly inadequate. So if I then just come back to the way we put it in the hearing statement, in terms of the failures to properly consider mitigation, we can identify at least 3 points. First of all, and on one view, this is not a criticism of the footprint report because it's not purporting to do otherwise, at least as we read it. But the footprint report itself doesn't consider all of the possible mitigation measures, though it certainly helpfully identifies, we would say, and positively identifies a number of possible mitigation strategies. Secondly, and this is a point I've just been making, the HRA, the updated HRA, the conclusions in it, are based on a fundamentally flawed reading of the footprint report, treating its positive discussion of mitigation without a conclusion about effectiveness as evidence of ineffectiveness, and that's just fundamentally wrong. And thirdly, to the extent that the HRA does address mitigation, and there is some discussion of it, see 4.21, 4.35 to 4.35. Again, it's just basing itself on what's in the footprint report, and it is not purporting to go beyond the footprint report. And furthermore, a further slightly separate strand of criticism. It's really just looking at each of the points as an individual isolated item. So there's no analysis anywhere of whether a package or the package of measures, even in the existing policy, let alone of the kind we're now proposing, will be capable of mitigating the harm. You just don't find that analysis. And just by way of example of that point, see please 4.27 of that report. This is on the subject of re-wetting of the common. What the HRA says, this is so 4.27 the HRA I should say, what the HRA says is, well, footprint doesn't say anything positive about effectiveness. Well, sure, it doesn't reach a positive conclusion about the effectiveness, certainly not of that in isolation, but that's because it doesn't purport to reach any conclusions about effectiveness of any of the measures. It just says, well, there might be some problems with them, there might not. We need to look further. So that's what I want to say under the heading of 1.11b. And that leaves you, if I'm right about that, in this position, that on our analysis of what's happened so far, there has not been a proper analysis of mitigation. Now, I take the point, it can be said against me, well, that doesn't get me home, because it can still be said that, that you wouldn't, on that basis, be entitled to reach the conclusion that mitigation will deal with the probable harm. You can just complain that the council hasn't done its job properly. But it's a pretty important starting point, because as I say, and this is topic C in 111, and it's the last subject I want to address you on, when you come to that topic, and when you come to consider the question of whether mitigation will address the harms, the proper starting point is that you have evidence from us, which is to the effect that it will. And Mr. Elvin has said he's not giving a full response to that. Well, fine, so be it, but that's the position. So we don't. I think it's fair to say we don't fully know what the council says about that. But there is nothing in the footprint survey on the in the updated HRA to set against that conclusion. This is not a case where you're being asked to set our HRA in terms of mitigation against the updated HRA and say, well, I prefer one or the other. Because the reality is that the updated HRA doesn't do the exercise at all. And so you straightforwardly have a full analysis from us, which we say you should accept. So that's the final topic. Question C, have alternative mitigation measures been considered? If so, are there any that would satisfactorily address the problems identified? Obviously, it follows from everything I've said to you so far that my answer to that question is, well, they have been considered. They've been considered by us, and they can be considered by you in light of our evidence. And you should conclude that the mitigation measures, the package of mitigation measures which we have identified, would mitigate the harm. So a couple of points of just of a general approach. I mean, Mr. Elvin makes a point perfectly fairly that you have to apply the precautionary principle. I'm not suggesting otherwise. Please do take a precautionary approach. That's the right approach. And you have to be satisfied beyond doubt that the harm can be avoided. Again, that's correct. But on the other hand, you do have to set that against the fact that we are dealing with this issue at plan level at the moment. The references to this are in our hearing statement, but the level of detail required at this stage is therefore limited. And the only question you have to be satisfied on is that the plan doesn't commit the council to a development on this site which is not capable of mitigation. Because if the allocation is capable of mitigation, i.e. the 500 houses and the 45 houses can be built in a way that alongside mitigation measures that you can be satisfied now are available, will deal with the harm, then there's no basis to say that the allocation is not legally compliant. That's the first point of legal approach. Second point, I just come back to the point I opened with. I mean, the council is the petitioner here. I understand this is a point of legal compliance, but what you're concerned with is the submitted plan, and the submitted plan contains SS19. So unless you're satisfied that it's positively unsound to have it in, then it stays in. That's the position. And thirdly, I've made the point there's no real analysis from the Council of mitigation. So what's the basis on which I invite you to conclude that mitigation is appropriate? Well, mitigation measures are dealt with in the mitigation measures report produced by Wood. That's Appendix 1 to our hearing statement, and that's in turn analysed in the Shadow HRA, as I've said. And the conclusion reached in both reports is that the very wide range of, and I do really emphasise the very wide range of mitigation measures available are capable, and in reality more than capable, of removing adverse impacts from recreational pressure. And they reached that conclusion on the basis of a site-specific analysis, coupled with, importantly, consideration of the effectiveness of, in many cases, rather less extensive measures on other sites. There are two key conclusions. 6.4.76, the mitigation package proposed is sufficient to mitigate for the risks that will result from the development of QEB and the other allocations. And 6.4.77, that if SS19 is removed, this goes back to the point I started with, if SS19 is removed, there will be no mitigation of impacts from other development, the other allocations, and it is therefore not presently possible to conclude that those allocations are legally compliant. Now, I just want to update you on a critical factual development in that regard. In the mitigation measures report, the reference is 6.4.58, sorry, I think that's the HRA reference actually, 6.4.58. A possibility is discussed of the provision by a DIO of alternative green space. That's to say, in addition to the green space on site, which is already envisaged and dealt with, what's envisaged is, if required, DIO could make available some additional land to further provide further mitigation by the provision of additional green space. Now, that was at the time of the mitigation measures report last month a possibility. I can confirm, and we'll get an appropriate letter to put on the file in relation to this, but I can confirm that that's now something we can definitively offer. Now, whether it's required in future, that's a matter for the future. But if it's required, DIO is able to commit to making that land available. To be clear, that's what's described as AGS2 in the mitigation measures report. AGS1, which was also being discussed, will not be made available, and indeed serves a separate function because it's used by the tenant farmer. So that's quite an important further degree of certainty which is available to you. So the simple question then for you is whether the full range of measures identified will be effective. They are all, in light of what I've just said, all of the measures identified in the report are available. And I'm not going to track through all of the detail of those points, but I've just got a couple of quick points to make about it. First point is, it's important not to overstate the risks which have to be mitigated. The common is currently reasonably well used, and that without there being at present any adverse impact on the SAC. And it's far from clear, it's a possibility we accept, but it's far from clear that an increase in visitor numbers of around 24% from all of the allocations will create adverse impacts. Secondly, there really is a very extensive range of measures available. And with the exception of new bylaws, all of those have been used elsewhere and proved effective. And in fact, taken as a package, and in principle, all of these measures are available. Taken as a package, they go well beyond what has been found to be necessary elsewhere. If necessary, they can all be implemented. Thirdly, the Council makes much of the fact that this is effectively on the edge of the common. They say that's a qualitative difference, as I understand it, and they say, well, it's within 400 metres of the protected site, and that makes all the difference. But there is a critical point about this, which is that you have to think about what the kind of harm you're dealing with here and what kind of distances matter. One can quite see that if the issue was, say, cat predation, as it was on one of the other sites, or if the issue was air quality, then the distance from the protected site you're going to be concerned with is distance as the crow flies. But we're not concerned with that. we're concerned with impacts from increased recreational use. And in that regard, it must be the case, just as a matter of common sense, that the distances which matter will be the distances which residents of the new development have to walk to get on to the common. Now, as to that, it's 6.8G of the mitigation measures report. The distances we are looking at are not in the range of 400 metres. They're in the range of 1.3 to 2 kilometres, depending exactly where you are living on the site. So, and that in the context of increased recreational pressure, that's got to be the distance which matters. Now, that's subject to, a point discussed in the footprint report, that's subject to putting in place effective fencing on the edge of the site, so that people can't just go straight onto the common from their the new residence. But there's absolutely no reason why that can't be done effectively. There's not currently public access points directly onto the common from the site. And it's obvious that one can design the scheme in such a way as there wouldn't be such access points. And that being so, this 400-metre point, of which the council has made so much, rather loses its significance. Fourth point, it's critical, I submit, to take account of the position of DIO as landowner of the common and its position as a public body with management responsibilities of the common as well as of the site for now. It's got bylaw making powers. It really is in a very special and unique position, completely different from the position you find in relation to the other sites. And you do have to take these, we say this is one of the flaws in the council's analysis, you have to take these measures as an overall package and ask whether they are effective overall. Now, some of the measures have been considered previously by footprint, but at least 4 of the measures which are identified in the mitigation study have not been addressed by the council at all. I'll just briefly tell you what they are. 6.8C Roman 2 relates to one of the aspects of the wardening, because one of the important functions that a warden can provide is as the enforcer of even existing bylaws. Secondly, there's the power to make new bylaws. I'll come back to the detail of that in a minute. Thirdly, there's a point about managed access. And fourthly, as I've just indicated, there's now available the provision of new additional AGS land outside of the red line of the site allocation, in addition to that which we provided on site. And we do invite you to conclude that some of those measures are going to be particularly effective in combination. I just ask you to think, for example, the reality is, and we've heard this from Mr. Lilly a moment ago, one of the key issues on this site is in relation to dog walking, and in fact the issue in relation to dog walking is in particular, principally as I understand it, in relation to sheep worrying, and somewhat secondarily in relation to dog fouling. Well, both of those are issues that can be regulated by bylaws, if necessary, certainly dogs on leads by new bylaws, and they are both issues, insofar as there are bylaws which address them, which can be enforced by way of a warden. And in my submission, bearing in mind that's probably is the key issue, it's pretty strange to conclude that whereas you have currently an unregulated position on the common, where the public can access the site with dogs, that matters would be worse by reason of a 24% or so increase in visitor numbers, in circumstances where the specific and most damaging problem, dogs worrying sheep, can be addressed by way of bylaws targeted at that very issue. It would be very odd, I suggest, to conclude that that is not a more than adequate mitigation of the problem. It goes well beyond anything that you see or which would have been possible in relation to the comparator sites in the report. And the other point I just finally want to finish with is in terms of managed access. 86% of visitors access the common via just 3 points. And all of that shows, we say, that targeted, and this goes to a number of the different mitigation measures, targeted monitoring, education, information sharing and wardening at these points would hit would affect the overwhelming majority of users.
Forgive me, Mr. Bewley. Can I just check? Are we sort of getting into the final furlong?
That's literally it. So, I mean, it's safe to say that the conclusion I'm inviting you to draw is that the very wide range of mitigation measures available are plainly more than effective. Frankly, would provide betterment in terms of the protection of the common, but certainly more than adequate to address the potential impacts by reason of the development being proposed. So thank you.
I think before we invite other interested parties to speak and the council right to respond to that, we should take a little break. Just to sort of have a little breath. It's just gone 4 o'clock now. I'd suggest maybe 15 minutes. So 20 past 4. 20 past 4, we reconvene then. Thank you.